the power of judicial review is an immense power that the Supreme Court has. And the question is, where in Article 3 is the Supreme Court given this power? The answer is nowhere. So the reading for today was the Constitution of the United States of America. And the version that we read was the original version of the Constitution before all of the amendments, the one that was written down on a piece of parchment or whatever. That's what we read for today. And there are just a few parts of it that I want to pick out and discuss. And then at the end, I want to say something about the nature of the kinds of rules that appear in the Constitution. It's going to turn out that they're all secondary rules in HLA Hart's sense. Let's take a look at something that appears in Section 2 of Article 1. Article 1 is the first article. It's the first, chunk of the Constitution, and it has to do with the legislative branch. It has to do with Congress and the kinds of powers that Congress has. Here is the first sentence of the third paragraph of Section 2 of Article 1 of the Constitution. Representatives and direct taxes shall be apportioned among the several states which may be included within this union. Okay, so we know that we're talking about how you calculate how many representatives and how much taxes to, apportion, to distribute, right? This is an issue. This paragraph is about how to distribute the number of representatives and how much taxes to draw from the various states. These things shall be apportioned among the several states which may be included within this union according to their representative numbers, which shall be determined by adding. It's according to the population, right? The population of each state is going to determine, how many representatives, for example, they have in the House of Representatives. And how are you going to figure out what the population is, what the numbers are of each state? Well, you determine that by adding the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The notable portion of this little calculation here, of course, is 3/5 of all other persons. This is the famous 3/5 compromise, wherein slaves in southern states, right, or in all states, slaves in all states were counted as 3/5 of a person for the purposes of calculating numbers for taxation and the number of representatives that would appear in the House of Representatives. The interesting thing to me is the fact that it didn't say 3/5 of slaves. It didn't say 3/5 of enslaved persons or 3/5 of colored persons or anything like that. It just says all other persons. And you're supposed to just read this and know that, they've already talked about free persons, and they've already talked about Indians or Native Americans. So the only type of person left are black slaves, right? You're just supposed to figure that out. The interesting thing is that when doing something that you might sort of feel is morally questionable, you sometimes have to, if not tell yourself a whole lie about it, you have to sort of push out of your mind some of the more unpleasant aspects of it. You can't focus on them, because if you focus on them, then the moral trouble of what you're doing will eat away at you. Another way to put this point is that euphemism, right? That is, the technique of using some indirect means of reference, right? Instead of saying that someone died, you say they passed away. This is euphemism. Euphemism is an incredibly powerful tool, and one way that it gets used is to let yourself do something that you're not certain is the morally right thing to do. You don't just put it out there directly in ink on the piece of parchment that you are counting slaves or black people in the United States, right, at the end of the 18th century as 3/5 of a person for the purposes of calculating the population of all the states, right? You can't just put that out there, because it brings it directly to your own attention as well. We saw this also earlier in this course when we read the case Korematsu. That was, you may remember, and if you don't, I'll remind you, that was a Supreme Court case just after World War II that was concerned with Japanese internment. And the situation there was that Korematsu, a Japanese American, was convicted of disobeying an executive order, a military order, that told him he had to leave his home and report to a relocation center or leave a certain area of the country, right? And he sued, and then what comes out in the majority and dissenting opinion, so the Supreme Court said that Japanese internment in this case was constitutional and that it was right to punish Korematsu. Anyway, but there's a dissenting opinion that makes the following crucial point. In order for the majority opinion of justices of the Supreme Court to hold that Japanese internment was constitutional, in order to do that, the justices of the Supreme Court had to basically lie to themselves. They had to pretend that there was only one order telling Korematsu to leave a certain area. They had to conveniently forget that actually there was another order that was issued in conjunction with the first order telling Korematsu that he couldn't leave the area. And so you had these two contradictory orders that meant basically that Korematsu, because of his race, had to report to what was essentially a concentration camp, a relocation center, a prison. The noteworthy thing there is that in order to come to that conclusion, the justices of the Supreme Court had to sort of slightly pretend that things weren't the way they were. They had to use a certain kind of technique of pushing something directly out of your mind or out of the direct view of your mind. And that's also what's going on here in Article 1 of the Constitution. But you may know, right, that, well, the Constitution no longer says this. This was the original text of the Constitution, but then there was this little thing called the 14th Amendment, right? Section 2, actually, I think, of the 14th Amendment, which was, I think it was passed by Congress in 1866, right after the Civil War, at the end of the Civil War, right? And then in order to amend the Constitution, a certain number of states have to ratify the amendments, and so the ratifications didn't all come through until 1868, right? And that's when you get the text here modified so that it's no longer the case that, well, slaves, there are no slaves after the 13th Amendment, which outlaws slavery. It's no longer the case that any Americans are counted as 3/5 of a person for the purposes of calculating the population of the states. Here's something else that I want us to notice also from Article 1. This happens in the next section, Section 3. This is the first paragraph. This one short sentence is the whole first paragraph of Section 3 of Article 1 of the Constitution. This is talking about the Senate and how we figure out who gets to be a member of the Senate. Notice if there's anything unusual about this. The Senate of the United States shall be composed of 2 senators from each state, chosen by the legislature thereof, for 6 years, and each senator shall have 1 vote. The weird thing is chosen by the legislature thereof. Today, senators are chosen not by the legislature of the states that they represent, but by the populations, by the people. There's a vote, right? They're elected. But in this case, it was the state legislatures that were picking the senators. That's how it was originally. This didn't change, actually, until I think it was 1912, when the 17th Amendment was passed by Congress, and then I think in the next year, 1913, is when it was ratified by enough of the states. Up until this point, senators were not elected by the people. Here's one other passage that I just want to talk about. It's a longer passage, so I'm not going to write it out. Maybe if I can figure out how to do it, I will edit the video so that the text appears somewhere while I'm reading it. But this is from Article 4, Section 2. Here's what it says. No person held to service or labor in one state, under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. Okay, what does that mean? What it means is that if slavery is legal in one state and illegal in another, and a slave escapes from, say, a southern state into a state in the north, well then, it doesn't matter what the laws of that northern state are. That slave doesn't get freed. They have to be returned to their owner in a southern state. That was the original text of the Constitution, and indeed, that is still the text of the Constitution now, because even though slavery was outlawed by the 13th Amendment, which was passed by Congress and then I think ratified, both of those occurred mostly in 1865. Even though from 1865 on, slavery is not legal anywhere in the United States, that fact, the 13th Amendment, merely supersedes that text from Article 4 of the Constitution. It doesn't modify it or erase it. It's just that it no longer applies. What do we notice about all of the text, or almost all of the text, that appears in the Constitution? Well, the first thing that we notice is that almost all of it are secondary rules, maybe all of it, right? In Hart's sense, HLA Hart's sense, a secondary rule, you'll remember, is just a rule about a rule. So everything here about how you figure out how many people go into, are apportioned by each state into the House of Representatives, all that stuff, those aren't ordinary rules that apply directly to citizens. They're not primary rules. They're rules about the bodies that make those primary rules. And so they are themselves secondary rules. They're rules about rules. So everything we get in the Constitution are secondary rules. And then if you go through carefully, you'll find that in some cases there are duty-imposing rules. There are rules that impose duties on particular government officials, right? And there are also power-conferring rules. So you get both of these, but only one of these. The last thing that I want to talk about is Article 3 of the Constitution. This is the article that deals with the judicial branch. It deals with federal courts and the Supreme Court. Well, what I wanted you to do when you read this portion of the Constitution was look for the place where it gives the Supreme Court the power of judicial review. Judicial review is the power whereby the Supreme Court gets to be the official interpreters of the Constitution. They get to be the ones, the Supreme Court, they get to be the ones who decide if some law that's passed by Congress or some executive order that is issued by the president, right, if those things violate the Constitution. And if the Supreme Court finds that they do violate the Constitution, if they are unconstitutional, then those laws or those orders or whatever are thereby struck down. They're no longer law, as long as the very small number of Supreme Court justices decides that they're no longer law. The power of judicial review is an immense power that the Supreme Court has. And the question is, where in Article 3 is the Supreme Court given this power? The answer is nowhere. The power of judicial review is not given to the Supreme Court anywhere in the Constitution. It's not given to the Supreme Court anywhere in any statute or law that's passed by Congress. The power of judicial review is something that the Supreme Court just gave itself in 1803. I'm going to make a separate video about the process whereby the Supreme Court gave itself the power of judicial review. But for now, I just want to convince you that it's not in there, that it's not in the Constitution. There are at least two places in Article 3 where you might think it appears. And let's just talk very quickly about each of them. This is the first sentence of Article 3. It says, "The judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain or establish." You might think that judicial review is given to the Supreme Court right there in the name. This court is supreme. But that's actually not what happens in this sentence, right? What's going on is that there's a certain kind of power, the judicial power of the United States, and it's given to Well, a hierarchical structure of courts, where there's one court at the top, the Supreme Court, and then there are other lesser courts, inferior courts, as they're called, right? And below those inferior courts are other, even more inferior courts, or whatever, and so on. What the word supreme here means is just that this court is at the top of the hierarchy. That is, its decisions trump the decisions of the other courts. They win out when there's a conflict. But it doesn't say, the fact that the Supreme Court is at the top of this hierarchy, that doesn't say anything about what power is being given to this system of courts, of which the Supreme Court is at the top. What the hell is the judicial power of the United States? Does it include the power to officially interpret the Constitution and strike down any law passed in the correct fashion by Congress because that court decides that that law violates the Constitution? Well, we don't know. Nothing in this sentence shows us that it does. Here's the one other place that you might think judicial review is granted to the Supreme Court, but where it's not. This is the first sentence of Section 2 of Article 3, right? So in Section 1, we said that the Supreme Court, or the Constitution rather, says that the Supreme Court is the Supreme Court and it gets the judicial power of the United States. And then in Section 2, we find out something about that judicial power. The judicial power shall extend to all cases in law and equity arising under this Constitution, so on and so forth. There's a whole bunch of stuff here about the jurisdiction of the Supreme Court and other federal courts, right? Jurisdiction is just the fancy legal word for logical territory. It's the landscape of cases that the court has power to make rulings about, right? To decide, those cases that it gets to decide. So here when it says that the judicial power of the Supreme Court, for example, extends to all of these cases over here and over there, right? That doesn't mean that the Supreme Court can, when deciding those cases, decide that one of the laws that's at issue in one of those cases is just not law anymore, right? It's one thing for the Supreme Court to be able to make a decision about a case, whether some action, right, was legal or illegal or something like that, right? How to decide a particular case. The power of judicial review is the power, while deciding some case that otherwise falls under your jurisdiction, to just strike down a law. That's not specified anywhere when you're specifying the mere territory of cases that a court can hear. So I really hope you believe me that the power of judicial review, this enormous, incredible power, although constrained in certain ways, that the Supreme Court has, I hope you believe me when I tell you that that power is not granted to the Supreme Court anywhere in the Constitution. I'm going to go make another video explaining how the court gave itself that power.